heard before. There's been some changes at the last meeting on number 12A. We made a few changes, and it was decided that it was substantially different from what was presented, so we're just kind of bringing this back in. We go over those very briefly. We've hit this several times, so.
For the record, Rob Buonamici, Chief Game Warden, CGR 389. We did go through, hear this at our last commission meeting in Ely. Did come up with several changes. We made those changes in concert with LCB. We worked with them to get the correct language in that they're agreeable with. So in your support material, I'll go through the changes. Basically, in section 1, except as otherwise provided in section 2, a person shall not obstruct, and then we insert or contaminate the flow of water to or the storage of water in a guzzler or other, and insert wildlife water development. Or B, in any other manner interfere with the insert function, cross out use of a guzzler or other, and insert wildlife water development. The provisions of this section do not apply to an officer, employee, or agent of the department or federal land management agency is inserted while acting in his or her legal official capacity as an officer, employee, or agency of the department. And then in section 3, as used in this section, guzzler or other, and insert wildlife water development means any artificial or enhanced natural basin that collects or is designed, insert, and constructed to collect and cross out water and insert precipitation for use by any wildlife. I'd be happy to answer any questions.
First, public comment, and then we'll have the commission come up with any questions for you. We didn't have any cards on this item. Was there anybody? No public comment on this item. Okay, closing public comment hearing. Back to the commission, Mr. Vogler.
I should have bought myself a camouflage cowboy hat because I'm putting on my cowboy hat now.
Oh.
There's a state law, water law, no water, even on private land, can be restricted from wildlife. Okay?
Correct.
Now, guzzler is supposed to be exclusively for wildlife. But the way this is worded, to a purist, a rancher, an owner of a water right, you're stating here that I would, if I went out to clean a water hole on public land or private land, because it says water collection for use by wildlife. It's all inclusive. All water in the state of Nevada is open to wildlife. I could not put a netting wire over a water hole on my private property to keep ducks off if I wanted to. It's just a matter of semantics. The other problem I have is right now, before the Attorney General, is a question for a ruling out of White Pine County, and I will disclose that I was asked by a White Pine County rancher to bring it before the Board of Agriculture, and it is before the Attorney General's office to investigate further the total legality of guzzlers. There's becoming a huge issue in eastern Nevada on these guzzlers. It's sort of like Christopher Columbus. You go out and you discover another one. For whatever reason, permittees are not entitled to even a notification or any prior notice that it's going in. NDOW says it's BLM's deal, BLM says it's NDOW's deal. But nobody notifies the rancher. And in some areas, because there are snow water permits, there are areas that have already been to the Supreme Court of the state of Nevada over surface water running into water holes, which would by definition, be a wildlife water development because they cannot be restricted. This is a giant can of worms, and I would like you to, I don't know who to sit down with or who to talk to it about it, but it's a bad deal for the people that use the public lands for livestock production, and we do not restrict water from any wildlife. And anyhow, the way this is worded, it's overreaching on private land, and it's also overreaching on people who have water rights on public land. Thank you.
Mr. Wow, does you have anything on that?
Yeah, a couple of comments on that.
We'll get
Number one,
right
it is designed for guzzlers and wildlife water developments. So we all agree on that. That's
Yep.
the intent. And a wildlife water development, you know, guzzler and other wildlife water development, and with the words constructed for that purpose, to me covers the issue. If you've got a livestock pond, trough, what have you, yeah, the law says you can't preclude access to wildlife. But that's not the purpose. The purpose was for livestock. So that's where I see the difference. There is no intent here to infringe upon ranchers' water.
I'm more than reasonably sure that's the case. And I'm sure if you will promise to live forever and I also can live forever, this will be all right. But if you get a barrister involved in this that wants to make a big deal out of this, the way this reads, it does absolutely include all water. In any way, designed and constructed for use by any wildlife. Well, anything I design or construct. I built 3 reservoirs on private land in Sampson Creek. Elk are in there by the gazillion. Deer are in there by the gazillion. The only thing that can't get in there is wild horses. But I built those reservoirs. Now, when they need cleaned out in a few years or a cloudburst comes through and washes them out, do I have to get a federal permit to go in and fix them back up? Because they will be used by wildlife. They're being used now. There's a duck with a bunch of ducklings in one of them, and the sage hens drink out of it. I just would like to see some much clearer wording that protects the permittees, protects the water rights of individuals. That's all. I'm not arguing with you. I understand the dynamics of this is to prevent people, as they do, because they do it to the pipelines over there. Somebody will have an antelope permit. They'll build the antelope shed or whatever, the condominium to live in while the antelope's coming to water. They don't want the water going down the pipeline, so they go break all the valves off. It's a law enforcement thing, yes. We should get something done about that. Or they pour Clorox in the other troughs so nothing will drink the water. There's all kinds of shenanigans going on. And I appreciate you trying to clarify and clean this up. But this wording, between you and I and what we've said here on the record, is fine today. But down the road, if somebody wanted to read this and go to the Attorney General without some clarity, this is a mess. Sorry.
Mr. Pearl.
Yes, sir. Thank you, Mr. Chairman. Rob, would this cause any concern for, he mentioned one thing that I had thought about, and that is if a person went in to clean or, remove silt or other things that were preventing, proper flow, inflow or outflow in that, would they be in violation of this because they are, in effect, altering the flow? If they temporarily altered the flow to perform maintenance work, does that cause any concern?
No, not in my estimation. If you look at the language in its entirety, if you look at the language in its entirety, and I think we're all on the same page here and want the same end. So that's not an issue. But obstruct, except as otherwise provided in this subsection, in subsection 2, a person shall not obstruct or contaminate the flow of water. So if you're cleaning something out, you're enhancing the flow. You're not obstructing the flow.
But at the time you're doing it, you may be obstructing the flow in.
And I think a judge would laugh us out of court, and a DA
Yeah,
would drop that case like a hot potato.
Okay, I just wanted to know, I may divert it temporarily to make the fix, to construct a box that makes that flow better and that, but I am obstructing it by doing that. I just don't want these guys to get in trouble for doing that, if that's what they do.
And if I may, sir, for the record, Hank Vogler, this also, you've inserted a federal land management agency. What would be wrong with the permittee or the owner of the water right?
In that case, you would fall under an agent of the department, for
I'm not an
example.
agent of the department, though.
No, if you called us and said, hey, I've got a spring here, a trough here, or what have you, and it's all clogged up, I'm going to go in and clean it out. And we say, okay,
And
you're
think,
acting as an agent of the department. If we
okay,
give you the
and do you think that the water right holders in the state of Nevada that will fight to the death over a thimbleful of water and who owns it and who has jurisdiction on it, now somebody's going to tell them I have to go to NDOW and a federal agency over a private water right that I own, and the only thing it says in all the deeds on the water is I can't restrict wildlife from using it, and now I'm going to have to get a permit from you guys. You're going to get me horsewhipped, sir. And I have had more comment on this little tiny thing here than anything else since I was announced to be in on this board. There are some very angry people.
Mr. Vogel, just try to. Do you think that we could come up with some? I think everybody is in agreement on what we want to do.
Yes.
Haven't heard in our previous meetings about this. Would it be possible to come up with some more reasonable language on this? Do you have some specific suggestions that could we work out today for changing this wording? If we could make a few words
for the record, or stock water right holder instead of just or federal land management agency, because it says in here, it says the provisions of this section do not apply to an officer, employee, or agent of the Department of Wildlife or federal land management agency or the owner of the water right. Now that doesn't include a guzzler, but that would certainly include any spring development, any reservoir, or any collection pond. For example, Antelope Valley out of Tippins.
The exact verbiage would be employee or agent of the department, comma, federal land management agency, comma, or
water right holder.
Would that suffice, sir?
Okay, the last one, there's something on that. I'm having a dead spot here.
While he is contemplating the rest of that, what is the department's view on or water right holder being attached to that?
Mr. Chairman,
Mr. Mayor?
my experience tells me that if you try to do this kind of stuff on the fly, you don't usually get it right. And from a timing perspective, I'd rather have time to sit down with Mr. Vogler and come up with some words that make some sense. Because if we make a decision, and then we want to change it again, we're back and forth. I'd rather, I don't know where we are in the process, but could we roll this over and have a chance to kind of...
You've got to have that everything by what, the middle of next month?
Question, how time sensitive? I don't see this as being a time sensitive issue at all. We could wait and be okay.
This is the first reading.
This is not a time sensitive issue. It's already in the process as a permanent regulation. So we're able to continue it as necessary until everybody's comfortable with it. So that's not an issue.
Just in the sake of expedition of this process, would there be? I'm thinking that would be the best course of action at this point, is to continue it and come up with some further language at a further time. Is that Mr. Macbeth?
Yeah, I think that's a good idea. For the benefit of Commissioner Vogler, I had some big concerns about this at the last meeting when we were talking about it, and we inserted the word precipitation to try to get it out of the context of a water right, okay? And so I can understand your concern, and I guess in addition to the language water right holder, I'd like to see maybe that defined, as a permitted certificated or vested water right or something along, and we have a DAG here who I know can come up with acceptable language because he also represents the Division of
Brief
Water
question
Resources.
about the DAG here. Mr. Stockton, on this particular issue, since this is not an action item today, can we go ahead and say, hey, let's just not even hear it tomorrow?
Oh, yes, definitely.
Let's
It is an act.
It is an action.
well, excuse me, it's tomorrow it's an action item. But today, it not being an action item today, can we just go ahead and
No action tomorrow.
and state now we want to not do anything on it tomorrow
Yes.
and direct the interested parties?
Yes, that's an internal administrative rule, so you can, I mean, it's not administrative, but administration of the commission, so yes.
Okay, I would like to ask in that case, if it would be the favor of the commission, I'd like to ask the interested parties here, specifically Mr. Vogel and Mr. Macbeth, to get with appropriate department personnel and perhaps come up with some better language on this and maybe we get our September agenda or future agenda.
Thank you.
And that being the case,
Thank you.
let's roll right on.